I'm not sorry. I'm not sorry to the guy in the car that jumped the light and sideswiped me. I'm not sorry that my serious injury, my suffering, is a problem for you. I'm not sorry there's a dent in your car. Not sorry you didn't see me. But you'll be sorry when you hear who my lawyer is.
Bates and Garcia. When good isn't just good enough, we offer you more than a typical law firm. Call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Hello, and welcome to the premiere edition of Law and Disorder. I am your host, Ivan Bates. And this podcast and all the future podcasts will talk about the criminal justice system, not just in Maryland, but around the country. We want to educate the listener, and we want to bring issues and topics that are relevant. The criminal justice system has done more to incarcerate individuals than anything else. There have been more people in prison in the past 20 years than at any time in our history. We want to sit down and look at what's been going on, what's happening, and how does the criminal justice system work. I'll have guests from various backgrounds, some individuals that work within the system, some that have worked out on the outside of the system, and some that have been inside the system. What do I bring, and what should you expect? I have over 23 years of experience as not only a state prosecutor in Baltimore City, but also as a criminal defense attorney. I've done cases in Louisiana, Virginia, California, Maryland, and Pennsylvania, just to name a few of the states. So I've done cases all around. I've seen the criminal justice system through the eyes of thousands of individuals that I've had the pleasure of representing, and I've also seen it through the eyes of the victims, having been a prosecutor. I know what works and I know what doesn't work. And my goal throughout the next few weeks of this podcast is to educate you, the listener. So any questions you have, please feel free to reach out to me either on Twitter at Ivan J. Bates on Twitter, or you can just go ahead and reach out to me at ivan@batesgarcia.com, my email. On today's edition, with our premiere edition, we're going to have a gentleman joining me by the name of Corey Woodfolk. Corey's a very unique individual, and he's an individual that I'm glad and proud to say is a friend of mine. We currently work together, but I'm giving you a little background about Corey, Mr. Woodfolk. Back in the 90s, Corey, as he was known as Big Corey in Park Heights, he was a person they'd say was a drug dealer back then. He was a person that ran a group that had done a number of things that caught the attention of the federal government. The federal government then, back in, I think, 1992, prosecuted Corey and his crew, and he was given 50 years by the federal government. So for all practical purposes, they gave him a life sentence. After spending a few years while incarcerated, he decided that he could do one of two things. He could work to try to change himself to become a better person, a better man, or he could sit down and just continue to be, as he will say, just raise hell and cause havoc. He decided that he wanted to be a better person. For the next 18, 19 years, almost every single day while he was doing his 50-year sentence, he went to the law library. He dedicated himself to the legal system, to understanding it, and not just his case, but the case of other individuals. And while he was there, he was able to get a degree in paralegal studies. And from there, he began to write briefs, he began to write motions, and he began to be able to show other inmates how through the legal system they could change their sentences. He filed a motion with the original Judge Motz, who sentenced him to the 50 years. And Judge Motz brought Mr. Woodfolk, Corey, before him. He was so impressed with all that Corey had done, he changed his sentence from 50 years to time served of 23 years. Corey was a free man. But what was that really going to mean to Corey? A mutual friend that we had, a gentleman who goes by the name of Stokey, he reached out to me to say, hey, I know a young man named Corey Woodfolk. He's getting ready to get out. He's a paralegal, and he's looking to do work. He wants to be a law clerk. I said, fine, send me his resume. Well, I really wasn't thinking, but a man who's been doing 23 years in the federal system really doesn't have a resume because he hasn't been working. He came for a job interview. And I like to tease him to say he had the same sweater on that I was wearing back in the 90s, Tommy Hilfiger sweater. And that I knew he had been in prison. He'd been someplace since the 90s. And I was really impressed. He played a tape recording, which was better than any other piece of paper could ever be. On this tape recording, it was the oral argument of a brief that he had written. And I heard a voice on that tape that I knew from being in front of this judge many times. Judge Andre Davis, the current city solicitor for Baltimore City, who was on the Fourth Circuit in Richmond, a federal judge. And he talked about how the pro se litigant had written the best brief by a pro se litigant he'd ever seen in his entire career on the bench. And he was so impressed. I heard the U.S. Attorney's voice say the same thing. And before he knew it, the U.S. Attorney had acknowledged that he really didn't have a real argument because Mr. Woodfolk was right on the law. With that, I knew that I needed to give this young man a chance. And that was about 2.5 years ago. I'm glad to say that from those early days of him wearing an ankle monitor coming to work to writing numerous briefs and motions, he was such an outstanding individual in integrating himself back into society that the government and the court system agreed that he should no longer be on what they call papers. They ended the 5 years of supervised release early. So he is my guest today on our first and our premiere edition of Law and Disorder. We will talk about the criminal justice system from cuffs to barbed wire. What does it mean and how do individuals get involved in the criminal justice system? But right now, we'll go ahead and take a quick break, and then we'll be back with Mr. Corey Woodfolk.
We all take precautions in life. We take every measure to make sure we and our family are safe. But when our worst fears become reality, when lives have been changed forever or worse, lost due to an accident, what next?
When something catastrophic happens to you or someone you love, call us.
When good isn't just good enough, we offer you more than a typical law firm. If you've been injured in a car accident, call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Welcome back. Once again, I'm your host, Ivan Bates, for Law and Disorder. We have with us today, joining me on our premiere edition, a friend of mine, a work colleague, Mr. Corey Woodfolk. Welcome, Corey. How are you doing today?
How you doing today, Mr. Ivan Bates? How you doing out there, everybody? I came today to speak with Mr. Bates and to all of you to give you an idea of what the criminal justice system is like and what change is like.
Yeah. Well, before we get there, I said a couple things about you. What do you have to say about your life and how you've gone from one point to totally changing your life to where you are today?
When you decide to change in your life, that change has to be based on one of several things. Either some horrific tragedy in your life forced you to change, or education. For me, the prison sentence itself wasn't the horrific change. I had been under a lot of pressure all my life, living in the Park Heights area and the way I came up. So for me, that was a part for the course. But education made a difference for me in prison. Learning the criminal justice system, studying the law, writing, extremely important, being able to communicate your message, being able to persuade. When I was able to do those things helped me to make a difference and decide that I want to do something different with my life and to do something for others in the process.
Okay. Now, are you the type of individual, I've heard many people say, man, Corey's like a movie. His life is like a movie. When you sit down and you look at your life, do you feel that when people look at you that you're a role model now?
For those that know me, I think that they saw, or I gave them the opportunity to see something different. Because you got to remember, when people know you from a particular era or particular time, they expect you to be that same way. That's just human nature. And it takes some time for people to believe something different. And inside of that, you have to make a decision in your life that whatever anyone else thinks, you're going to make a difference in your life. If they see it, then so what? And maybe it works out really good for you and them. But if they don't see it, you just keep pushing. Maybe you'll be able to help somebody else along. But you can't wait for nobody else to, accept you being or changing.
When we look at the criminal justice system, we talk about mass incarceration and the new Jim Crow, and we just look at how the criminal justice system has been modern day slavery. When you look at your time and the things that you were doing and that you pled guilty to back in 1992, do you think that you needed to go to prison at that point in time?
I believe I'm probably a little different than some others that are caught incarcerated or get locked up. For me, I thought that I deserved every single day they gave me. For me, in the streets, the way I lived my life, the things that I had did up until that point, I needed to be placed in a controlled environment. It wasn't that I didn't have principles and that my family didn't raise me the right way. I chose to make decisions that I knew were wrong. But for me, the time that I went away to prison was a time that allowed me to become someone else. Had I not went to prison, then of course, my story would be completely different. So for me, even though that 23 years and 6 months was of course a long time, that time was needed for me to do something different with my life, to change. And sometimes change takes a while.
So when you went in, how old were you?
I was 23 years old.
And when you came out, you were what?
48.
48. So you spent at that point in time, when you were at least more than half your life, you'd spent in prison.
That is correct. And
you'd agree that, I guess, you were two different people.
There's no question about that. The way I thought when I was 20, I didn't think when I was 40. When I was 40, I don't think different when I'm 50, so I'm pushing close to that now.
Okay. One of the things, I want to do with this podcast is I want people to see the criminal justice system and real people, hear real stories. Today, we're going to talk about the criminal justice system from the state point of view, and I'll talk about what happens on the state side in the state of Maryland, and you'll talk about what happens on the federal process. And the way I want to start this out is I want to have a hypothetical. So let's say there's a guy, and let's just call him Steven. Steven's a drug dealer, and he's in Park Heights. And he has a drug crew, he has a drug organization. And on the state side, Steven gets arrested. And I'll talk about what happens with Steven being out in the corner, sitting there selling drugs, and what happens when he gets arrested on the state side. And you can talk about Steven sitting there with his friends, his crew, selling drugs, and what happens on the federal side, and so that people can understand how you can get involved in the criminal justice system and what happens on the state and federal side. So let's say it's a hot day. Steven's been out there selling drugs in the corner out there in Park Heights, and he's been operating this, owning this block where he sells drugs for the past year and a half. Every day, it's either Steven or someone of his 10-person crew, and they're selling drugs. On this one particular day, the police stop Steven after they see him do a hand-to-hand drug transaction. And when they stop Steven, let's say he has about 25 gel caps of heroin in his pocket. They recover the drugs off the person he's sold them to, and they also get $1,500 out of Steven's pocket. When Steven is initially approached, he's arrested, you have the first thing you look at, they're going to ask him to make a statement. And the first thing they'll say is when they approach you, and the police are in a covert location, meaning they're hiding, and they see all this happening, and they make their arrest, and they go up and they put their hands on Steve, and they put him in handcuffs. They'll say, you have the right to remain silent. Anything you say can and will be held against you. That's the first thing that happens. Once they're in police custody and the police put the cuffs on you, the Constitution initially and will always make sure your rights are protected. And so once you have that on the state side, in Maryland, for instance, you'll be arrested. It's a drug case. It's not a big drug investigation. At that moment in time, they will probably just take you to central booking, where you will see a commissioner. And once you see a commissioner, within the first 24 hours of your arrest, the commissioner has the ability to grant you bail. But let's say the commissioner doesn't grant you bail. If the commissioner doesn't grant you bail, or say the commissioner sets a bail that's so high an individual can't pay it, then the next day, most likely, or later that day, you'll see a judge. So the first person on the state side that you see that can release you on your own recognizance, can give you a bail, or they can ask that you be held without bail, is the commissioner. And if the commissioner doesn't grant you that bail and doesn't release you on your own recognizance, then you'll have the opportunity to see the judge. What happens on the federal side, Stephen?
The federal side is a little different. After he's arrested, with the same circumstances generally, first thing he's done, of course, is read his Miranda rights and advised of his right to counsel and things like that. Now, at that point, the feds, when they pick you up, they're not looking for you right away to make a statement. They probably, most of the time, they could care less. Most of the time, will feel like they got enough evidence against you that you can keep it to yourself.
So in a federal case, they've probably been out there watching you and have wiretaps and everything.
True. The next day, you'll be arrested that day. The next day, only within the first 24 hours, you'll go see a magistrate judge. The magistrate judge will, at that time, you'll have a chance to have what's called a detention hearing, possibly, that day. The detention hearing is different than the state side because at that detention hearing, a lot of times attorneys will waive it for that initial hearing so they didn't get time to get certain things together. Third-party custodian, place to stay, because most of the time, they're just not going to let you go. If you want to be let go for detention on the federal side, you're going to have somebody have to speak up for you. You're going to have something to put up. And it makes a difference in that sense. So that's a little different than on the state side where you can pay a bail and get right out. After you have your detention hearing in the court, if it decides to let you go, you put you on house arrest, family, friend, somebody, that the probation department determines will be a good third-party custodian. And then at that time, if you have a job or something to that effect, you can go out, ask for that you be allowed to go out to work during the time that it takes for you to proceed to trial.
One of the things that has been interesting to me when you look at the bail situation, on the state side, you have cash bail, but on the federal side, you don't. On the state side, the judge will sit down and listen to majorly just two major issues. One, are you a potential flight risk? And number two, are you a threat to the community? On the flight risk, they're going to sit down and see, have you absconded before? Do you have substantial ties to the community? They'll look at the charges. And they'll see if you have a job, you have a family. What are the things to make sure that you will appear to court? They'll also sit down and look at the charges to see you a threat to the community. For instance, here you have drugs. If it's just 25 gel caps of heroin, you really don't have a real record. There's no guns or anything like that. There's a high likelihood that you probably will be released, particularly on your own recognizance, if you're not already out on bail. And if a gun isn't recovered, then that changes things. Then it's more likely that you will not be released on bail. And then, when you look at bail, you have a number of bail bondsmen who you can pay a certain percentage of the bail to, anywhere from 10% all the way down to 1%. They'll go ahead and pay to have you released on bail. And, the other thing that's very interesting, looking at the bail system, there's no bail on the federal side. However, in Baltimore City, they do not have electronic home detention through the jails. And if they do, then it's such a small charge and so few people can receive it at the initial arrest. However, on the federal side, if I'm not mistaken, there is electronic home detention, correct?
That is correct.
Now, one of the things you talked about with a third-party custodian, I do a lot of federal work as well. I was amazed to see that if a person is receiving subsidies,
Section 8
subsidies from the federal government, they're not eligible to receive somebody from the federal system to be in their care.
That's correct.
Now, the other thing that's very interesting, if a person committed a crime, say that they're selling drugs in Park Heights, and their whole family lives in Park Heights, that family really isn't eligible to have their loved one come back to their house in Park Heights because they live in Park Heights. Isn't that correct?
And that's so because that neighborhood is generally associated where the crimes took place.
Exactly.
And that makes a difference.
Now, I want to talk about the charges. On the federal side, if they see Steven selling drugs and they say he's just out there by himself and he's not there with anybody, he'll be charged with a count called possession of intent to distribute. The maximum penalty for that is 20 years and a $25,000 fine. And that's on the state side. If he's selling drugs with somebody, they can charge him with conspiracy. And once again, conspiracy of possession of intent to distribute, that's a $25,000 fine and 20 years in jail. Provided you don't have a prior record, then they could give you enhancements and things like that. And so those are the two charges that you normally will see 99% of the time of, based on Steven, who's out there selling drugs on the corner in Park Heights. What if a person's selling drugs in the federal side, what charges could they potentially face?
On the federal side, the federal side is, besides the statute, which is 21 U.S.C. 841, the federal side is governed by the federal sentencing guidelines. Now, under the 21 U.S.C. 841, the court determines how much you can receive as sentencing based on the amount of weight that is charged in the indictment. So, for instance, if it's at least a kilo, and the federal government generally works the case, and by, whether it's just, as a consequence, but generally they work the case until it's at least a kilogram of either heroin, a particular amount of cocaine, whatever the drug is, it'll be enough to place you into the 10 to life category. That way they'll have more room to sentence you to a greater sentence. Now, if they don't charge weight and they just charge what's called an undetermined amount, then it would be under what's called 841 B1C, which is a catch-all provision. It's 0 to 20 years.
So you could be looking anywhere from 10-year minimum mandatory on up for the drugs, and they could sit down. They could also look at anywhere from 0 to 20 years, depending on the amount of drugs.
Correct.
Now, with the federal government, they could also charge you for RICO in terms of you and your whole crew. They could say it's a criminal enterprise that are out there selling drugs, correct?
Under the RICO statute, that's 21 U.S.C. 1961. You got 18 U.S.C. 1961, 18 U.S.C. 1959, one which is called the Hobbs Act for robbery. 61 generally encompasses any other crimes that are state affiliated, like drugs. And the RICO is racketeering, influence, corrupt organization, using this organization to commit crimes through. So the underlying act for the RICO would be the drug distribution. Then you would have overt acts inside of that, which tends to increase your sentence, whether it's robbery, shootings, homicide, rape, all those kind of things.
So basically, Steven's out there one day selling drugs, and they get 25 jail caps off of him. On the state side, Steven's only facing that one count of the 25 jail caps. On the federal side, they may only recover 25 jail caps off of him, but they may have telephone calls, and they've watched him and his buddies sell drugs, and they've been arresting everybody from his crew for the past 6 to 8 months, and they can then easily say, we've gotten a kilo to a kilo and a half of heroin, and they basically charge the whole organization for a kilo or more of heroin, so then they're automatically looking at a minimum mandatory of 10
to life.
To
That's
life.
correct. But in that particular instance, when they come, if the federal government comes to you, you have 25 pills in your pocket, they probably throw them on the ground because they could care less. When they come, they got what they're looking for as far as the weight. The indictment is already satisfied. They're looking to put you in that category so that they can get you kind of sentence that they're looking for.
So once you've been arrested, let's talk about getting an attorney. Retention of counsel and the Fifth and Sixth Amendment. On the state side and the federal side, you can hire a private attorney on both of them, correct?
That's correct.
And but it's important. I do state work and I do federal work. It's important on the federal side that you really make sure that you're dealing with an attorney that just doesn't dabble on the federal side, but really knows what they're doing. Someone that is potentially on what I would say the CJ panel. And let's talk about panel attorneys and public defenders. On the state side, you have public defenders. On the federal side, you have public defenders. On the state side, you have a panel attorney where an attorney is a private attorney that gets paid by the state, correct?
That's correct.
On the federal side, you have CJA attorneys, and these are attorneys that work for you, the individual charged, the federal government is paying, but they pay them at a higher rate. So can anybody just be a CJA attorney, or you have to be selected?
Well, you have to be selected, and you have to. They require you to give them a written sample. You have to have had a few cases that you've worked on inside the federal case. Give a dissertation of the legal issue that you brought before the court, how it ultimately processed, even if it didn't prevail. But you have to do a little more on the federal side, and you have to show them that you're proficient in the federal sentencing guidelines, because the entire federal system is governed by the federal sentencing guidelines.
Well, one of the things, I'm on the CJ panel, so we do a lot of CJ panel work. But one of the things I know we've talked about is, when you have a CJ panel attorney, or at least attorney on the federal side, they tend to be some of your better lawyers.
That's true.
And that's because they're hand-selected. And usually, like in my case, I was asked by a federal judge that I had a trial in front of. He pulled me to the side and said he wanted me to be on the panel. And that's important, because being on the panel allows individuals charged with and looking at substantial amount of jail time to really be able to have some of the best lawyers of their own to represent them without them paying. And the other thing that I know is really big on the federal CJ panel is that if you need an expert, the federal government pays for that and everything, correct?
That's correct.
Now, in pricing a private attorney, is a private attorney more expensive on the state side, or are they more expensive on the federal side?
Federal side.
And why would that be?
Well, on the state side, everything is pretty standard. You get your indictment or your complaint. Following the indictment complaint, you file whatever particular pretrial motions. If it's going to be a trial, it's going to be a trial. And that's it. On the federal side, it's just not about the statutes and the pretrial motions and all those things. The federal guidelines govern everything that's interrelated into that case. Your sentencing, you got the rules of evidence, you got so many other things that are required the attorney to know inside the federal system that's not required on the state side. So, of course, the fees will be, of course, somewhat higher on the federal side than it is the state.
Well, now we've taken you through the time period. You've been arrested. You have your lawyer. You know your charges. You're either held without bail, or you've been on the state side, or you may be released on your own recognizance or posted bail. On the federal side, you're in a situation where you've had your detention hearing. You're either detained, or you could potentially be released to a third-party custodian, or you could be on electronic home detention. Now you're getting ready for your case. And getting ready for your case, is there a time period that on the state side and the federal side where your case should try to go forward within a certain time period? A lot of times people say, what is my speedy trial time or speedy trial date? What is that?
180.
What is it?
180 days.
So basically you're supposed to, on the federal side and the state side,
That's correct.
have your case tried within 180 days.
That's correct.
However, on both sides, they can go ahead and have a postponement, and they could push it out past 180 days.
That's true.
On the state side is a thing called Hicks. And Hicks says in the state of Maryland, you need to have your case tried within 180 days from the date of the arraignment on the circuit court level, or the date in which your attorney entered their appearance on the circuit court level. Now, in the state system, it's a little different. On the federal system, for instance, once you're arrested, it's the same system. On the state system, once you're arrested, all cases start in the district court. All cases. So your Hicks right doesn't begin until your case is in the circuit court, which is the higher court, which means that you can be arrested on January 1st. And it takes about 30 days in the state of Maryland for your case to go from the beginning of the state and district court to having the actual first district court date. Your district court date more than likely will be what's called a preliminary hearing. A preliminary hearing will sit down and say, you go before the judge and the state puts on evidence, only one witness, an officer who's going to read a statement of facts, most likely, or be asked a couple questions. The judge finds whether or not there's enough evidence to believe, probable cause to believe that you, the individual charged, has actually done or you're actually guilty of what you're accused of. It's only probable cause. So they don't need to prove beyond a reasonable doubt, but is it more than likely that you did this? If the judge finds that there is, then this case will be sent from the district court to the circuit court. The other way a case can go from the district court to the circuit court is by an indictment. There is a grand jury. The grand jury sits down in the circuit court, and the prosecutors, as a secret process, they'll take one witness, usually a police officer or officer for the case, and they'll go before the members of the grand jury and they'll read them the information. The officer will testify. Based on the officer's testimony, the grand jury will listen, and based on that, they'll come up with the indictment, and the indictment will be whatever the charges grand jury feels the state has what's called probable cause to say that, yes, you more than likely did the crime. So here the grand jury, if you're looking at Stevie's case, would look at the officer's report. The report would pretty much say on such and such day, such and such time in Baltimore City, they saw a gentleman identified as, say, a black male known as Stevie Johnson, and they saw him, and they would lay out what they saw him doing. Then they'll sit down and talk about how they recovered drugs from them, and that the drugs were tested and they came back positive for heroin. From there, the grand jury would listen to the information and they would decide to vote to indict you. And once you're indicted, your case goes from the district court to the circuit court. And then once you are arraigned, and usually once you've been indicted, so your case comes in, you've been arrested January 1st, your case now is set in for preliminary hearing on February 1st. You're indicted on January 30th. Your arraignment date is now March 1st. So your speedy trial right under Hicks, your Hicks right, doesn't begin until March 1st. On the federal side, there are very few preliminary hearings, if any, but there are a lot of indictments, correct?
That is correct.
And the federal side, is that the way the case then is taken before the grand jury?
Well, on the federal side, the United States attorney can charge you in what's called a complaint. And you can actually plead to a complaint without there being an indictment. Of course, you have to, with counsel, waive your right to indictment and agree to plead to the complaint. Generally, that happens when the prosecutor is offering you something a lot less lenient, and you believe that, the case against you may be somewhat stronger, even though you haven't seen all the evidence, and then you may decide, okay, I'll just plead to the complaint. But if not, then of course they'll indict by the grand jury, and the process pretty much moves along just like the state side as far as time.
One of the things I know that they do on the federal side with the grand jury is they tend to take almost every single witness who they plan to testify in your case before the grand jury. So on the state side, Stevie may only be charged by the officer with selling drugs, and so only the officer will go there. But on the federal side, they may have 20 people from Stevie's organization charged, and 5 or 6 of those individuals may testify that Stevie is the leader and that they've watched Stevie, purchase kilos of cocaine or heroin, and then they take those individuals before the grand jury, correct?
That's correct.
So that's a big difference from the state side and the federal side. On the federal side, they tend to put the witnesses in front of the grand jury. What does that do when you put a witness in front of the grand jury?
Well, when you put a witness in front of the grand jury, it prepares that witness for trial and things to come, and it also gives the grand jury a chance to hear a lot more information and evidence against you.
Okay, but also that witness is locked into their story, correct?
That's correct.
All right.
And you can use it for impeachment purposes at trial if they change their stories.
Okay. Well, right now we're going to go ahead and take a short break. When we come back, we're going to talk about a couple more issues and differences between the state system, criminal justice system in Maryland, and the federal criminal justice system nationally. Once again, this is Law and Disorder with your host, Ivan Bates.
We all take precautions in life. We take every measure to make sure we and our family are safe. But when our worst fears become reality, Well, lives have been changed forever or worse, lost due to an accident. What next?
When something catastrophic happens to you or someone you love, call us.
When good isn't just good enough, we offer you more than a typical law firm. If you've been injured in a car accident, call us today for a free consultation at 410-814-4600 or visit us online at batesgarcia.com.
Law and Disorder with Ivan Bates is produced by Andy Pierre and brought to you by the DMV Daily Media Group, Maryland's leading podcast network, offering you a wide variety of informational podcasts and programs, including the award-winning daily program, the DMV Daily Radio Show, which airs Monday through Friday from 5 to 6:30 p.m. only on DMVDaily.news. You can find out more information on this podcast and on other podcasts and programs produced by DMV Daily by simply going to the website, www.dmvdaily.news. Be sure to follow DMV Daily Radio on iTunes, Stitcher, TuneIn, and Google Play, or watch episodes on the DMV Daily Show on Facebook, Periscope, or YouTube at DMV Daily News. You can also donate to this independent news outlet by simply going to paypal.me/DMV Daily News.